pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Hello, this is Constitutional Attorney Catherine Henry. Welcome to this episode of Restore Freedom Weekly with Catherine Henry. Each week, I'm going to start us off with a Bible passage that'll help. No, just kidding. Each week, I'm not going to start us off with a Bible passage. Good afternoon. Excuse me. Good afternoon. I'm Constitutional Attorney Catherine Henry, and
You're
I can't
looking
talk
up
today.
You're looking at
I'm
the
looking at the wrong
camera.
Okay. That's awesome. Well, hello. I'm just full of faux pas today. I'm Constitutional Attorney Catherine Henry, obviously a very real person, not super scripted. And I'm with you today on this episode of Restore Freedom Weekly to bring the Constitution and the law to you, to make it accessible and understandable, to bring government to you in an accountable, accessible way. You can't be we the people of the Republic, this Republican form of government, right? You can't do that if you really don't know the Constitution or the law. So with that being said, I hope that you find some grace for our beginnings here today, because I didn't realize I had pressed the old intro button and that it went right on past Emma's part and on into an intro that I'm no longer using. So I apologize about that. And if you want to comment on either the lighting changes today or the camera angle, that would be great, because we have a new camera and we have new lighting that an expert in the field has so graciously offered to help me out with and see if these work. But obviously it's all a work in progress, so we would love to be able to make sure we're doing things the best way and not making it look up my nose too much or anything else that would be a little undignified. So today we're supposed to have sorry, I'm going to text the person that we're supposed to have. He's asking where he's supposed to be right now. So anyway, Lori, I don't know if you want to send it to him again. I got your text, but maybe it didn't go through or something. All right. So, and it looks like we have actually Dale on Facebook. Before I get too far into today, that's actually your question goes to why my special guest, well, he's not that special. No, why why my guest is supposed to, and I'm looking at the wrong camera. I'm going to put that camera down. Okay. Why my guest is supposed to be hopping on and joining us today. So anyway, we're going to kind of start a little bit fresh here today, especially for any social media platforms we might be re-airing this on later on. So with that being said, I'm going to reintroduce myself and have us officially get started. So hello and welcome to this week's episode of Restore Freedom Weekly. I'm Constitutional Attorney Catherine Henry. Today we are going to be talking about the concept of gag orders and the constitutionality or not of those particular items. It's something that you all have heard the term about, but oftentimes people don't know exactly what it means. So we're going to talk about what it means and the context within court proceedings. And then we're going to look at how it plays out, what the Constitution really says, what it allows, what it prohibits. And we're going to look at even what some of the cases, and you know, guys, I just don't like hanging my hat too much on cases, case law, right? But we'll touch on what some of the cases have even said about this throughout the years, all the way up to the U.S. Supreme Court. And then we're going to touch on some statutes that have been through the, part of the legal system, part of our system of government for many, many years. One, in fact, has been on the books, at least in Michigan, since 1846. That predates at least 2 constitutions in the state of Michigan. But at any rate, let's see here. Where is... Okay, so hopefully our guest will be joining us, because we do have somebody who on Facebook today, Dale on Facebook, is asking, did I hear about President Trump? And quite honestly, I myself have heard, or I should say read, literally just the drop-down notifications from the Epoch Times and, an email or two about it. I think Rumble, I got a notification on a drop-down today saying, that there was some sort of live video where they're talking about his situation here in Florida. But with that being said, since I'm not that well informed about it and didn't even read a full article about it, I'm going to bring to you the handsome, super sexy, very intelligent, but way older than me, Mr. Michael Henry. What was that, Mike? I'm not hearing. Lori, are you able to hear him okay? Lori, are you hearing him? What's going on here? Okay. Lori, or Mike, can you speak up a little bit louder? I didn't catch what you said there.
Oh. Maybe he's having issues with his sound.
Yeah, it's just noisy in here, and my earbuds don't work.
Can you hear us okay?
Just a little bit, yeah. I think I can manage.
Okay, because we can actually, I can at least hear you way better when you took the earbuds out. So, for whatever that's worth. My lips are definitely not syncing up on the video feed. Uh-oh, my whole feed is frozen.
Yeah, I noticed that from the beginning.
Oh.
I thought it might be my connection, but I don't know.
Not if it's mine as well. Well, Mike, unless you have some...
You synced myself, but I'm not looking at the live. I can watch the live.
Oh, I'm just looking at the screen, that you and I can see, Lori.
Well, now you're not. You were a minute ago.
Okay. Who knows what's going on? Okay, so the Liberty Cause has not frozen or out of sync here. So we'll just roll with it and see what we got. And hopefully I'll remember to try to look at the correct camera this time. All right, so before we get started on today's topic of gag orders, well, hey, it may be related, who knows? Mike, who he only puts Mike, but he brings the Henry to the Restore Freedom with Catherine Henry show. And he often jokes that he is just known as Mr. Catherine Henry. But really, Mike, my wonderful husband, can you please enlighten us on what exactly is going on with President Trump today?
Well, I'm on because I tried to suggest something for you to bring up, and you thought it'd be a good idea for me to do that. So unless you've been living under a rock, you've probably heard that Trump's home in Florida at Mar-a-Lago was raided by FBI yesterday. At least that's when I saw the first news of this, was last night. And they claim it's over some presidential documents, some documents that they're saying were supposed to be left at the White House, but there's some, I don't know, it sounds like there's reason to believe that that's a lie. So, but we all know what's really going on here. This isn't the first FBI raid recently on so-called political enemies. I would really encourage anyone watching to do some research and look up this raid on Trump's home, and we need to get to the bottom of this and figure out what's going on. And in my opinion, we know what's going on. This needs to be put to an end. This is abuse of powers.
All right. So, were there any other details that you thought? Assume that everybody has been living under a rock and they haven't had a chance to dig into the news yet today. Is there anything about this, specifics that you might have heard about? Did you say, are they still there, or how long this was, or how many showed up?
Well, I don't know if they're still there. I imagine they're probably still there. There was, I heard there was 30 agents. I heard there was many black SUVs filling up the some kind of roundabout parking lot or parking or driveway there. I heard they rented a type of U-Haul truck to have armed agents inside, and they, so they could all get out from this truck when they got there. And I heard that they have been working with FBI on trying to sort out all these documents that they're claiming that Trump has or in his possession. And they've been doing that through Trump's attorneys, and it's all been peaceful until this raid that was all of a sudden and far more aggressive than any communication or any actions that have been taking place before. So.
I just, reading the words really makes it sink in. We have people on YouTube commenting about this, as well as others on Facebook saying the same thing, that they broke into his private safe. They broke into his private safe and found nothing. I just, we each as citizens have that right to unreasonable searches and seizures. And I want to know exactly, in plain, simple language, how they think that is not a Fourth Amendment violation. I mean, it's disgusting. And
at the least,
I think they don't think about the Fourth Amendment, though, because they have been getting away with it. Not every single one of them. I think we should be clear. It does seem like a majority lately because we've been surrounded by it, but I don't think every single law enforcement officer is like this. But if we look back, they've been, due process has been missing. They have parts, they follow it to a certain extent, but when they really want to go after somebody, they don't care about due process. They just do whatever they can to get you on whatever they want to get you on.
Right. Well, I'm not gonna, that could be a whole nother, we'll do a whole show about the Fourth Amendment at some point soon, but we have a lot of topics as well, and the one we're talking about today is very timely. I
think that it's very telling that Trump has been talking about this. His sons have been talking about this, and when there's a raid like this, the first thing your attorney would tell you is to just stay quiet. Well, they're not being quiet, and it seems to me the reason is because they don't have anything to hide. That seems to make sense, and I don't believe they do have anything to hide. I think this is a political witch hunt.
Exactly. So I see this comment I wanted to share, but this is an interesting one I just noticed as well. I didn't think I had missed any, but anyway, very interesting. It is something that I think the governor and the sheriff down there definitely could be doing something and should be doing something. And where are they? I mean, maybe they're involved. Maybe they're doing what they can and they're doing, a bunch of literal pushback. But
well, DeSantis is involved. He has made public statements. I haven't heard what it is yet, but it's out there.
Okay.
I was going to say, though, can't the sheriff boot? I mean, the feds don't have authority in a county unless the sheriff gives them the authority to be there, right? I mean, that's kind of the short explanation.
We need to actually dive into that whole topic. So, hey, Lori, if you happen to have that spreadsheet open, you should put that very topic on there so we can remember to. I want to dive into it and really do it right. And some of these things, I know, the surface on the top of my head to be able to answer some of that stuff, but I really want to make sure that I am combing through the Constitution front and back to make sure that I'm answering those kinds of things correctly. So leave it to Lori to stump me live and not bring it up earlier. But let's see here. So we're going to get back to our main topic about gag orders. I was just trying to think if there's anything. I guess, Mike, are you able to just, stick around, throw yourself on mute if you needed to, and jump in on the topic of the gag orders or the documents specifically from this case, if you think of something that you wanted to share?
I can be around, but I'm going to get off video. I got to go get something to eat.
Oh, you don't want to eat on camera? Oh, okay. Well, yeah, you could turn your camera part off. And
food is overrated.
I haven't eaten yet today. I didn't even have a shake yet. So
I know, exactly.
So if you hear a there's no bear. It's just my stomach. But hey, Mike, I think if you're able to, yeah, you could turn off your camera and then, well, I guess mute yourself. And then when you're ready to talk, just turn your mute back on, or your camera. I'd prefer if you had your camera. So.
Alrighty.
All right. Thanks, babe. Love you.
Yep. Love you too. Bye.
And wait a minute, Dwayne on Facebook. I know you. I know where you live. Don't give me too hard of a time. Lori definitely keeps me on my toes, but sometimes I'm not that good to keep up. So, all right. Okay, let's see. Back to today's topic. Now that I'm got my wherewithal about me, and I wanted to share this screen with you guys so we can okay. All right. So for today's topic, and I'm going to, I guess, go ahead and find that original comment I had highlighted there. Okay. Lori, if you see anything that you think is good to have us throw up there as comments, while I'm talking about this stuff, I'm not necessarily going to be watching the comment thread as closely, so feel free to hit the show button. Okay. So back to today's topic, specifically about gag orders. And for those of you who like to play along, so to speak, there is we do our true or false Tuesday. We do our post poll on all the social media platforms that allow polls. I can't all, but I want to say it's like, 7 different platforms maybe. We have Truth Social and Telegram, YouTube, I can't even think of the other ones right now, but Twitter, LinkedIn, and 1 or 2 other ones. But anyway, unfortunately, Facebook took polls away. I'm not sure when or why, but yeah, whatever. At any rate, we put out every Tuesday. We try to do it right at 10 o'clock in the morning. And we're ironing out some kinks now and trying out some new software soon to make that process a little bit more slick. But at any rate, we do our best to post the question at at 10 o'clock in the morning on Tuesdays before the show, and then post the answer at 10 o'clock at night. So it gives a full 12 hours for people to be able to go on there and answer. So if you want to cheat, I guess, as it may be, figure out what today's answer is by listening to this episode, and then go ahead and answer the poll and answer it on all those social media channels. And then, you'll be the knowledgeable Constitution rock star, right? So at any rate, oftentimes we get so used to, we get accustomed to the government telling us what we can and cannot do, especially in the court system, right? We saw for example, the Michigan legislature, that, and there's specific legislators that come to mind that claim to be those ones that were fighting for our freedom and they want to be reelected. They were in office already. They had the platform, right? They were already office holders. And yet they were choosing to act like they needed to bring a lawsuit against the governor in order to stop her unconstitutional EOs, when none of them did what they could have simply done right from day one, stood on the steps of the Capitol along with me, Ryan Kelly, Kristen Megan, Adam Heikela, Chris Shornack, and other people that I'm totally forgetting, and I'm sorry. But anyway, they could have stood there right with us on the steps of the Capitol and said with that microphone, and every single news media station would have picked it up nationwide, quite frankly, at that point. And they could have said, listen, as your state rep or as your state senator, I'm telling you that this is not constitutional. And you don't have to follow unconstitutional edicts. You don't have to follow unconstitutional orders. And yeah, we'll file lawsuits to get things put into place in the, procedural or technical sense to stop her, but you don't have to do that. And they could have made a specific call to action. Look right into the eyes of every single law enforcement officer in the state and said, and I call on you, sheriff's deputies and police officers and campus security and whoever else out there is in that law enforcement type of role. I call on you to enforce the supreme law of the land, the Constitution, and not these illegal and unconstitutional orders. If you try to enforce these orders, you will be stepping far outside of the bounds of your authority and violating and trampling upon the very Constitution that you swore an oath to uphold. They could have done that. But what did they say? They cowered behind the institution and said, oh, well, we can make the laws, but that's all we could do. And so we have to file a lawsuit against the governor and wait for the court to tell us what's lawful and what's constitutional. How ironic is that? The legislature publicly, repeatedly said, we have to wait for the court. We have to wait for the judicial branch to tell us, the legislative branch, what our laws say. I don't know about you, but that sounds stupid to me.
Well, since they're the writer of laws, that sounds yeah.
Exactly, which it didn't fully connect to me until I was saying it out loud, and I'm like, that's a facepalm moment right there. But that's how it's ingrained in us to think that way, that we have to wait for a court's permission. Let me think about it this way. How many of you have heard of Matt DePerno at this point? He's the Republican nominee for Michigan Attorney General. Anybody and everybody who's listening, watching, let me know live in the comments here that, whether you've heard of Matt DePerno. If you have, let me ask you how long you have heard about him. So did you know of him at the end of 2020 when he started to do some work? Well, let me tell you, I heard about, Patty's raising her hand that she has heard of him. I heard about Matt DePerno. Actually, Mike, my husband, found out about Matt DePerno on, I just realized Mike left the whole dang thing. He said he was going to stay on.
Yeah,
Lord.
he texted me. He was having some technical issues, so he can't hear what's going on. So he's listening to the show, I believe. He just can't be in StreamYard and listen to the show at the same time.
Okay, sounds good. I guess he'll have to jump in if he's ready to say something or whatever. But yeah. All right, so dang, that threw me off. Where was it? Oh, Dwayne, you voted for him. Dwayne, are you saying you voted for him at the April convention? Just wondering about that. Kimberly says she didn't know about him until Trump endorsed him. Well, all right, Dwayne.
He's getting popularity with Nessel bashing him.
Oh, and he sent me 4 freaking emails just yesterday alone. Oh, Nestle's trying to arrest me. Shut up, Matt. I don't need your damn emails. I've tried to unsubscribe. I'm going to try again. But 4 in one day about the same thing? Really, dude? That's overkill. Don't be a politician. But anyway. All right, Dwayne. This is to both you and Michelle then. Well, no. This is to everybody. So Matt and I had a conversation that actually I've been trying to have a follow-up conversation with him about this now that he's when he was running to get the Republican nomination, but then as he moved into having that nomination out of the April Republican convention. So I wanted to have this conversation with him privately at first, but he's apparently way too cool to ever return a call or a text. So we're just going to talk about it right here. The thing that concerned me the most, I would say, about Matt running for office is that there was a gag order. He had a gag order placed on him by the judge in circuit court in Antrim County when he was filing his lawsuit in order to try to get those, I'm losing all my words. What are they? Help me out, Lori.
The tabulator stuff.
Yeah, oh, come on. Yeah.
I think we're too in sync. I'm just out of whack too.
The research. Yeah, he was. I'll say until we get one. But yeah, he was trying to investigate the results. Wanted to have a forensic. I'm almost there. Forensic audit, maybe. Is that right? I think
a review, forensic audit or review. I guess they're kind of.
He wanted to have
but they're not.
an independent forensic audit done per the Constitution of the tabulator machines and whatever else to be able to figure out what's going on. So he filed that lawsuit, I want to say late November, I want to say 3 weeks action. He filed that in late November 2020. By, I want to say it was mid-December, maybe somewhere around December 14th, but I'm not quite sure. Anyway, my husband found him online, found out about this lawsuit, saw him on Twitter, said, hey, I think you should check this guy out. I happened to see one post he had made about something. I think he might have even been talking about the gag order, but he was saying something about having the results of the not being able to publicly share them yet. So all I did is I sent him, I don't think I could have sent him a personal message on Twitter because he had that part shut off or something because we weren't connected on Twitter. But I just commented on one of his posts on Twitter and I said, hey, make sure that you remember to use, and I'm going to forget. I know what year it was enacted, but I can't think of what the statute number is. Dang it. Give me a second, guys. I am not doing well today. I am blanking on all my knowledge. It's going.
I threw you off, and now you're completely off kilter.
Yeah. MCL 600.1420 is the statute in Michigan that's been enacted since 1846. Yes, 1846. So it's been around longer than at least 2 of Michigan's constitutions, if not longer than that. At any rate, and I'm going to get, I guess, let me do this. I'm going to remove this for a minute. Okay. So I brought us back here because I realized I'm not going over the document yet. So I'll share it with you guys in a minute. You can pull it up on your own. We have the link to the PDF in the description of the video. There's 3 PDFs that we'll go over today, and I'll explain them in a minute. Dwayne, I'm giving you a hard time because you're a good friend, but I do want to tell you this important now about him. And I hope somebody can convey this message to him and have some real discussions and find out where he's at today on this issue because it's important. So at any rate, sent him, like a reply on one of his tweets and said, hey, don't forget about MCL 600.1420 because that requires all hearings in the state of Michigan to be open to the public. Period. There's 3 very rare exceptions. None of them applied in that case, and nor did anybody claim that they applied. So the judge can't keep the public out of those hearings. And he said, he actually sent me a direct message on Twitter, because apparently I couldn't send him one, but he could send me one. And he said, hey, here's my cell phone number. Can you please call me right away? Like, he saw my post and he wanted me to call him right away. So it was like 10 o'clock. I did. We had like an hour and a half long conversation about the case, about the law, about the Constitution. Here's the thing. And he was trying to bring truth to the people. So don't get me wrong. I'm not judging him. I'm not saying up to this point he has done anything wrong. This is my concern, though, is that we get to the point in the conversation where he tells me, okay, listen, this is Matt DePerno talking. I have the results to this audit, and the judge has ordered me under a gag order to not introduce this or not release it to the public. The judge has said I cannot release these audit results to the public, but he simultaneously has ordered me to turn it over not only to the named defendant, which I want to say was the county clerk in the case, township clerk maybe, but anyway, the local elections officials. But he said the judge ordered me to turn this audit information over to the I want to say he said the Secretary of State and the Michigan Attorney General, who, at least as of then, was not a party to the case. And do so, this was, I want to say, like maybe on a Saturday, and he was supposed to turn everything over by Sunday or Monday. And the order had come out, I want to say, like Saturday morning or Saturday afternoon. So the judge was expecting him to have this super quick turnaround to turn over these files, essentially. And mind you, they're computer files, right? It's not something you just print off. I mean, yeah, you can end up printing off the data, especially as it's analyzed, whatever. But the files as they exist are computer files that are so big that, I mean, I called my dad to say, hey, if you have a file this big, how can some options for getting it out there? Because you can't email it to anybody. What are some ways that he could even send it as it's, being required to be sent? So at any rate, so he said to me, he said the judge ordered me to not share it with the public, but did order me to share it with all these specific government agencies. And I said, okay, but ordering you to not share it with the public is, especially, I mean, you're in your private capacity, right? You're not serving in a governmental position. You're not representing any government entity in this case. So you represent a private party, the plaintiff in this case. That's totally unconstitutional and illegal for the judge to do that. He responded to me, and this is the bright red letters. He responded to me, but you have to follow an unconstitutional order until the higher court tells you you don't have to. Those are the words from Matt DePerno, Michigan's Republican nominee for Attorney General. I'm going to repeat that. He said to me, you have to, and this is in his capacity representing a client. He's supposed to zealously advocate for his client. And he said that even though he agreed with me that the judge's order, the gag order, put in place against him so they could not share at the time, they could not share the audit results of the tabulators and all that. Even though he agreed that that order was illegal and unconstitutional, Matt DePerno said to me, but you have to follow blatantly unconstitutional court orders until a higher court tells you you don't have to follow them. I don't know if it's just me, but I feel like I want to have a pause on that moment. And okay, we have BS. So Dwayne, I would love to hear what the BS is. I'm not sure if you're saying calling BS on what I'm telling you he said, or calling BS on what his statement was.
I think he was referring to the statement based on the timing of his comment. But I think that is deep rooted in us, that we have to wait for the courts, because it's something they say on TV shows. It's something they say on the news often, especially the news when they're reporting something. Well, we have to wait and hear what the court says. Now, that doesn't excuse Matt being an attorney. He should know better, of all people, but it makes sense that, for lack of a better word, the indoctrination on our nation is that we have to wait for the courts. I was talking to you about books I was looking at for paralegal stuff, just to pick up basic stuff. And the first thing they were saying is the courts. It's case precedents, what they're calling case law, is priority over the Constitution. So that mentality is even there in the training of these legal professionals as well. And then so there's that combination of what we're being taught in school in general, just general education, from our news that we're supposed to trust, that we don't trust, but we still listen to. And then, legal education is also teaching that. And I've looked into that history a little bit, not enough to speak about it, but I understand where it came from. And that mentality came from, and people just stick with it without thinking for themselves.
Well, Dwayne, I thank you for your comments, and I always love to have just have you throw you right on in as a guest with video and everything in one of our upcoming shows. But Dwayne, I know a lot of people in the freedom movement in Michigan respect you, so maybe you can have a conversation with Matt DePerno about that and see where he stands on that issue. Shoot, you put up one. I was just going to put up somebody else. Thank you for joining us, Dwayne. I see that you have to head out for another thing you got going on. And maybe this will get back to that, but we'll come back to Patty's Facebook comment in a second. What I wanted to do is show this one real quick, if it's going to let me. Maybe it's saying, no, Lori got to pick. Nope, it's not going to show either one. Dang it. What is it doing? Okay, there we go. Okay, so this was somebody's comment. And now, it's a comment on a live video feed, so perhaps I'm being a little too, but there's no punctuation. So my concern, how I read this is, well, we have this case precedent that tells us that it's unconstitutional for these gag orders to be put in place. Now, what I'm going to say to you is the Constitution exists wholly separate from any cases that are there interpreting the Constitution. In fact, there is no interpretation allowed where the Constitution is point blank, straightforward, easy to understand, simple language. There's nothing to interpret. There's no further explanation needed on it. So I'm hoping what this post really means is, well, we case from, I don't remember, I want to say that's the 1800s. I've quoted it in my briefs before, but it's been a while since I've read it and everything. But anyway, the Norton versus Shelby County case is a case that came out, many years ago. But
1886, I looked up.
See, I was pretty smart on that. I was thinking 1890, but yeah, 1886, that's close enough. So that case, the value in that case is just to serve as a reminder that it's unconstitutional for things like this, not to tell us in the first instance, oh, hey, this is unconstitutional, because the Constitution exists in and of itself. And hopefully that makes sense. So then you had this other one. Okay, good. Before I jump to Oh, see, you and I must be clicking them at the same time.
I'll
So
let you click.
no, you could do it. Normally I'm not. I just happened to catch this that he followed up. It's just the rare instance that we're literally doing it at the exact same time. So anyway, yeah, the person with that pointed out that his point is that his or her point is that it doesn't need to be declared unconstitutional. It already is. That's what I was doing was there is that basically this case is just serving as a reminder that if something is unconstitutional, sometimes we just need the reminder, but it doesn't need to wait for a court to tell us. So with that being said, I gave you an example. So by way of that example, I also defined what it is. But just for those of you who maybe were only hearing bits and pieces, a gag order is where, at least in this context, I'm talking about something where basically a judge is ordering you to not disclose information to anyone, certainly not out into the public. Sometimes there's a period of time that gag order is in place, specifically worded in the order. Sometimes it's just left open-ended. Now, the other side to that, so for example, today's question, let's see if I can pull it up quickly enough here. Maybe not. Okay. So today's question for our true or false question of the day was gag orders. Gag orders are unconstitutional aside from the rare exception, ? And your options were true. Gag orders are unconstitutional. Or false. Judges can prevent people from what happens in court hearings and trials. Now, we know that judges do that, but are they allowed to do that? That's the question we're talking about today. So with that being said, I want to go over what are some of the things that go into this? Because is there something in the Constitution that talks about gag orders, like directly, explicitly? Well, no. There's a lot of things that aren't specifically, our founders didn't take a sheet of paper and quill and just start writing out every single thing that government should always be prevented from doing and say, well, if it's not listed, then go for it. No, that's not the case at all. It's quite the opposite. If the government is not given a specific authority within the Constitution to take a particular action, then it cannot take that action. Whereas we, the people, look at the 9th Amendment, look at the 10th Amendment. We are, in the 9th Amendment, we are keeping all of our unenumerated rights. Our rights are given to us by God anyway, not the government. And in the 10th Amendment, anything that we are not specifically, oh my gosh, I cannot think of wording today. My words are leaving me like.
If the authority isn't specifically granted, is that where you're trying to go?
Yeah, delegated word. Any powers that are not that we don't specifically delegate, meaning we have power. We have all the power. We have all the authority. We have rights. Government doesn't have rights. Government doesn't have any inherent authority or powers. Keep that in mind when you're thinking about Romans 13. But in our system of government, in our Republican form of government, the only powers that the federal government has are ones that we have specifically delegated to it. Look at the wording of the 10th Amendment. Then we are, allowing in the 10th Amendment, it's essentially saying, well, there are all these other powers. We are either keeping ourselves or we are turning around and delegating some of what remains to the state governments. The government doesn't inherently have any power. We have to give it power. So
I think a visual example could be parents versus teenagers. Most parents, when their kids are in the teenage years, they usually have a set of chores that need to be done for the household to function. And we realize living in this society that there are some chores that need to be done for our society to function on a regular basis. So we as the parents are delegating specific authority. Child A is always going to be bringing out the garbage every Monday, while child B is always going to be making sure the dishwasher is loaded, done, and emptied, that kind of stuff. If people can visually put that in their mind that we are the parents and they are our teenage kids, that's the kind of authority. The moment we start letting government tell us what to do, it's as if we're letting the teenager tell us how the household is going to run.
exactly. And I love this one. My computer is totally lagging, so we'll see. Delegation is a temporary loan of power. That is correct. We are loaning powers. We are not permanently giving the government any powers. It's still a government of we, the people. So, all right. So now I'm going to get back to what we were talking about here. So, well, let me shoot. Do I have an example? I do. I'm going to read to you. Yeah, because I don't think I have any. Shoot. Don't think I have any available right this second that I could just show you by way of screen share, but let me pull up the exact wording and share it with you that way. Okay. So, in my case, the Allegan County Election Day Trespass Case that has now been dismissed over a month ago, it was dismissed July 7th. Every single time that we had a hearing until July 7th, just recently, the public was never allowed in. Never. There were 2 hearings, at least 2, maybe a third, but anyway, at least 2 hearings that I was physically allowed in, but no one else, not even an attorney, was allowed in the courtroom with me. And the judge said, well, it's, when I said, because it's not open, this hearing isn't open to the public, I would request that I get a copy of the video recording from today. And the judge said, he corrected me, and he said, well, of course this hearing is open to the public. We're broadcasting it live on our YouTube channel. So at any rate, the thing is, they delete it right after YouTube. He was deleting the videos of my hearings immediately as soon as the hearing was done. So I'm not sure how that could really be considered to be open to the public. But also, in order for me to then, because they were deleted and because no one was allowed in there and media was not allowed in there, because the public was not allowed to see what was happening, I requested copies of the videos, of the DVDs. I was charged $20 for copies of each hearing so I could get a copy of these DVDs. And I explicitly put on each of these that I wanted these for the purpose. You have to put what purpose. You have to tell them a reason for your request, which you should never hearing. But I said for preparation of my case, and for educating the public, because I'd been doing hundreds of these educational videos by the time this had happened. So anyway, for each of these, the judge approved my request to get the copy of the DVD, but in so doing, he has that, I don't know if it's him or just somebody else in that district court, but somebody in that courthouse drafted this form that is pre-printed to have it granted or denied. It should never be denied. But if it's granted, it's pre-printed with 3 check boxes for different limitations, right? So it's approved. The copies approved herein shall not be, in capital letters and underlined, shall not be copied, copied or reproduced in any form. That's number 1. Number 2, released to anyone other than the requesting individual. Number 3, published or posted on any form of electronic or social media, including but not limited to intranet and internet forums, web blogs, photo blogs, online web communities, listservs, internet diaries, instant messaging, text messaging, podcasts, amateur video sites, and all web postings, such as those in chat rooms, on bulletin boards, websites, or web pages, wikis, public shared email, online compilations of photographs or videos, and links to any of the foregoing items are also prohibited. That's pretty dang specific, saying that I'm not ever allowed to share these videos of these public hearings with any other human being ever. That's a gag order. So it was, of course, one of the many things that I was fighting in my interlocutory appeals that I had filed. Of course, that the Court of Appeals never bothered deciding on the merits. But it's something that I brought back up in my motions that I filed in front of the same judge in May of this year. And it's one of the hearings that was supposed to be heard on June 2nd, but that he moved to July 7th. Now, July 7th, for those of you that were either there that day or saw it later, you know, saw it, I shouldn't say later because there was no later, saw it live online. The, sorry, my computer is having fun. Okay. For those of you who saw the video live or were there that day, you know that once the judge, he was particular about which of my motions, I had several, he was particular about which of my motions he was going to hear first. And he heard the one about trespassing, then dismissed the case for the trespass case. Then he went to my motion to dismiss the disturbing the peace complaint, that charge. So then once both the charges were dismissed, he said, well, that's it. You know, I'm not going to hear any more of your motions. And I, you know, at the time said, well, at the very least, Your Honor, I do need to make sure, you know, that I'm getting my, I can't even think, my arrest record and my fingerprints and any biometric data, whatever, that's going to be, you know, properly removed from the system, and that my personal identifying information is also going to be redacted in accordance with the court rules and Michigan Supreme Court directives, etc. So, and he said, yeah, okay, go ahead. All right. So from that point, though, he was making it clear he was not going to hear any of my other motions, which were still pending before him. So there was no decision made on those. So essentially, I reviewed my request as to that issue, as to the gag orders on my DVDs. And I filed that last week. One of the documents is one of the original motions and briefs, supporting legal briefs, that talked about open hearings in general and different pieces to that we have the right to have open hearings in general, that we have the right, there's a constitutional requirement, let alone a statutory or legal requirement to have hearings, court proceedings open to the public. All across the country, the Constitution requires that. So I talk about that, and then I talk specifics. And the last part that I talked about, I think it was the last part, was specifically, you know, sharing it, having media and the public being able to, you know, share video and, you know, transcripts and show what's happening in this court proceeding and why it's so important. So I also gave you another one of the documents was the most recent motion I filed and the proposed order. And I filed it as an ex parte order because the requests to get the videos are done ex parte anyway. You shouldn't even have to file a request to get a judge's permission to get the video. But anyway, so I asked in this ex parte order for clarification and fully expecting that the procedures, would be followed, where essentially reviews it and he signs the order, providing that I will have these unrestricted copies of these DVDs, that I could share them with the public, that I could use them for future legal proceedings, etc. Well, he didn't sign it. And I was told that he granted my newest request that was sent at the same time for the DVD of the July 7th hearing, but that he, instead of granting my motion, my ex parte motion, to be able to share these videos with the public as they're required to, be able to do, the judge said instead that he was going to set my request for a hearing. And no one yesterday at the court would tell me when the hearing would be. Today, I finally got the notice of hearing. That is the motion hearing. Third document, that PDF that I've shared with you in today's description of the video. At least it's one of the three, right? It's the third I'm describing. And that's my notice to appear. And let's see. Man, my computer is just having a hard time. So he's doing it by Zoom to have this ex parte motion for clarification of records. Of course, I'm going to have to request another DVD for $20 for a copy of the hearing on this motion.
Are you able to make that any bigger?
Yes, I can. Give me a second here. Right, I gotta make this window smaller. Make that one bigger. Okay. So, is it big enough? Okay.
Yeah.
So this is the notice of hearing that I had just received. That it's by Zoom, of course. That's a whole nother story. And it's set for Thursday, September 1st at 11 a.m. So I hope all of you are going to tune in that Thursday. There's a Zoom link, or no, the public would have the YouTube link. And I'm assuming the amazing Lori is going to get this on our online calendar, so you'll be able to see what it is and have the link right in the description, so you can just click that out of the calendar that's on our website and watch that day. I really hope that your point is the public needs to have their eye on our judicial system.
Big time.
At any rate, getting back to some of the main comments, or the main discussions here, I guess. Let's see, is it big enough? Oh, that one went a little too much. All right. Okay, there we go. Okay, so I first pointed out to the court, this is the motion. This is the one where I said, hey, listen, I already filed a legal brief on this issue. I fully briefed the constitutionality and illegality of doing this. These are just the highlights I wanted to, remind you of, court, when it comes to this ex parte order should be signed that allows me to share the DVDs of these court hearings. And to repeat that, just so you know, I'm asking that the court allow me to have, I have the copies of most, there's still one, now there will be 2 DVDs that I still have to get yet. But other than that, I have the copies of the DVDs of all the other hearings. I already have them in my possession. but the court has said I'm not allowed to share them with any other human being. So my request is, hey, I do these educational videos, number one. Number two, the general right of the public to know what happens in court proceedings requires that these be shared. And number three, I have future litigation, and I have groups of people, teams of people that need to sit down and be able to meet and discuss, view these videos, discuss what's going on, discuss what our next moves are going to be for future litigation. So this is needed. So anyway, this is just the highlights, right, that I want you to use, whether you're the next Matt DePerno in a case where, you know, you're just trying to work on a generally, you know, a public interest case, such as election audits, or whether you are, you know, in more of a localized topic, you're in some sort of case about, you know, zoning or you know, other kind of government regulation, and a judge is ordering you to not share information that has been disclosed during the public hearings. Or there is a court such as, I don't know if they're still doing it, but as of last year, at least the courts around here were still doing all their hearings by Zoom and Zoom alone. And we're denying ADA have them in person because they're stupid. STUPID, which is what I called the prosecutor that day in Allegan County. But anyway, they are stupid for denying that, because now they're explicitly violating federal law, but they're also violating the Constitution. They don't, they claim, you know, think about it. The people that advocate for gun control are the ones that are saying, oh, well, you have to look at the Second Amendment only protects the weapons and things that people would have had then. You can't, it doesn't, you know, even though it doesn't spell out the word like muskets or anything, that's what the argument has been, right? Oh, well, the Second Amendment only applies to things like muskets because that's the only technology that existed back then. Yet these are the same dorks that are turning around and arguing in support of things like, oh, well, sure, court hearings can be done by Zoom. And yeah, that still means it's public because, you know, we have this technology. Guess what, guys? In the 1700s, there was no Zoom. There was no YouTube. So in order to make a hearing actually open to the public had to physically be allowed in the courtroom, and the proceedings had to be in the courtroom, and the parties had to all be in the courtroom, not appearing by some technology methods. They want their cake and eat it too, and it doesn't work that way. So
Now, this one might throw you for a loop, but you talk about having cases open to the public, but there is limited seating. Is that, we think about like open meetings when they have a meeting in a small room, but more people show up. Is that a thing the judicial system should be doing, is making arrangements for the bigger audience when there is a bigger audience?
Okay, I wasn't going to cover that point in this, but I did cover that point in so if you go to my website, the resources, and you go to case documents and Allegan case documents, if you look at my procedural due process appeals brief, you're going to see the full argument that I submitted talking about, you know, the whole concept of courts trying to limit the amount of people that can be in the courtroom. I went through that in very large detail, very fine detail, I guess I should say. So that brief, that legal brief, is available on my website. Again, the resources tab, case documents, and then look for it's like the second half. It's talking about the procedural due process appeal, the application or brief that I filed to the Court of Appeals. You'll see that argument there. You can look at the table of contents, and see where we were talking about open hearings and the limits on how many people can be in the courtroom, and you can read that whole argument that I fleshed out there. So, all right. So what I did have for you in today's documents, and this is in the motion and brief that I filed in May. That's one of the documents I shared again with you today. There's a section on page 17 of that brief where I'm addressing the 10-person limit. So I'm just going to read what's there. It's just a paragraph. Despite policies that the courts might have otherwise, court proceedings cannot be limited to only 10 people, as public access to proceedings cannot be as to render the openness negligible. Now, that's a quote that I pulled from another case earlier in the brief, but just repeated that part of it there. In a criminal proceeding, there would be a judge, a court reporter, a prosecutor, a defendant, defense counsel, and a deputy at the minimum. That's 6 people. So that only leaves 4 or less spots open for the public, which is a negligible openness for any non-trial proceeding. In a misdemeanor, when you have a jury trial, that's at least 6 plus an alternate. So that would bring it to a minimum of 13 people for a trial, plus any witnesses. So you're already far greater than that 10 people before even allowing the public in the courtroom. And so this is addressing Lori's question, because the courts have been trying, since COVID, they've been trying to limit how many people can be in a courtroom. It is foreseeable that a trial court might think that these, requests that I was making to the court to have, the court fully open to the public, that might be difficult to implement when they're so worried about all the COVID regulations. However, even if, and this is a quote from a, let's see, this is right out of the Michigan Judicial Institute, so the Michigan Supreme Court, their branch that educates the judges. They have a public right to access remote hearings, legal analysis that was published and updated in July of 2020. And it cited a U.S. Supreme Court from 1980, so applies all over the country, right? Case precedent. Anyway, so this is the site here, that even if all of the alternatives admittedly present difficulties for alternatives to allowing people just to be in the courtroom, even if all of the alternatives admittedly present difficulties for trial courts, none are beyond the realm of the manageable, absent an overriding interest articulated in court findings. The trial of a criminal case must be open to the public. And it's not just the trial, it's the other proceedings as well. Because a lot happens in the pretrial hearings and proceedings that controls how the trial is going to function. And the public needs to see what all goes into that. And I also had something else in the footnote here, that since generally expense, this is a quote, expense is not a justification for a constitutional shortcut. That's the Michigan Supreme Court in 2020 saying that. Certainly expense, and this is another quote from the same case, expense is not a sufficient reason for sacrificing face-to-face testimony. And that was the Iowa Supreme Court case from 2014 that the Michigan Supreme Court was quoting in 2020. So anyway, that is an answer to Lori's question that she posed, as Dwight's keeping me on my toes, but I guess I have those toes poised and ready to go. But some of the other things I wanted to highlight really quick about this concept of gag orders and what the court is allowed to do or not do. And generally speaking, this applies to any kind of government action, any kind of public bodies that meet, although there are different specific laws, generally something called the Open Meetings Act, or something of that nature, Sunshine in Government or something like that, I think is the Florida version of the Open Meetings Act. At any rate, each state has something akin to that. There's a federal version. We talked about those maybe a month or two ago in a different way. So this is specific to courts, right? So it's talking about gag orders. This is from a Michigan Supreme Court case from 1985. So it's been around a long time. Funny to me, it's Midland Publishing Company versus District Court Judge. The reason why it's funny to me is because my dad and my stepmom are from Midland, and I was living in Midland and opened my very first law firm that I opened myself in Midland, Michigan, and definitely was in front of the district court judges in Midland who would have been involved in this kind of case. But anyway, so this is from the Michigan Supreme Court in 1985. And again, other states have very similar wording from their own Supreme Court cases. But the First Amendment of the U.S. Constitution guarantees, the First Amendment guarantees of freedom of speech and of the press, protect a right of act places traditionally open to the public, such as trials. Wait a minute. So the Michigan Supreme Court, many, many years ago, is acknowledging that the First Amendment to the U.S. Constitution is specifically protecting, so the right of speech, your right to free speech, your right of the press, in the press to publicize information, right? That those rights protect the right of people to go to court proceedings. And specifically here, the cases are talking about that traditionally the courts have been open to the public. So it's not something that's just new that we're fighting about. This is something that's been commonplace because it's inherent in our way of government. Okay. So then another point to consider, a judge issuing a gag order. A judicially imposed gag order is a prior restraint. It's talking about First Amendment and your right to free speech or freedom of the press. When you have an order that stops you from speaking about something before you've even done anything, that is a prior restraint. So a judge issuing a gag order like the one I read to you earlier, or the one we talked about in Matt's case, that is a prior restraint on your free speech and is therefore subject to the strictest scrutiny by the courts when they're looking at these issues. The publicity of trials, the open forum of public trials, plays a very important role in ensuring and preventing abuse. It's serving as a natural check on the unjust prosecution and abuse of judicial power. And that comes out of that Detroit Free Press case, but it's also in several other Michigan Supreme Court cases and, of course, U.S. Supreme Court cases, including the one that's been cited by these Michigan Supreme Court cases. The U.S. Supreme Court case, for those of you that are interested, is In re Oliver, and it's been around since 1948 and still on the books. So that's something that, of course, would apply all over the country. So again, you have access to these 3 PDFs that we're talking about today that I have open in this window. Those are the links to those PDFs are in the description of this video. So prior restraints on publication, sharing information, right? So prior restraints, an order, a gag order like this that prohibits me from sharing the DVDs of the hearings in my case with the public. those are the most serious and least tolerable infringement on First Amendment rights. And because of that, anyone seeking to justify a prior restraint must overcome a heavy presumption of unconstitutionality. That is the wording of the, excuse me, that Midland, Michigan case from 1985 from the Michigan Supreme Court. But they were citing the U.S. Supreme Court case from 1931 and a Supreme Court case from 1976. So again, all over the U.S., this holds true, right? That when you have a gag judge who's trying somebody ahead of time from sharing information about a court proceeding that needs to be open to the public, that gag order, that prior judicial restraint is it's presumed, heavily presumed, to be completely unconstitutional, and it's the most serious and least tolerable infringement on our rights that are guaranteed and protected by the First Amendment. With respect, this is a quote again. This quote being from the from that Michigan Supreme Court case, but they are referencing a U.S. Supreme Court case from 1985. With respect to judicial proceedings in particular, so court hearings, the function of the press, the media, serves to guarantee the fairness of trials and to bring to beneficial effects of public scrutiny upon the administration of justice. That's what I've been saying. We need the public to be able to see, have their eye on all that's happening in cases in order for the people doing their jobs, the attorneys, the bailiffs, the judges, the court clerks, whomever, everyone doing their job, if they know the public eye is on them and can see what they're doing, they're more likely to follow the rules, right? They're more likely to do what they're supposed to do. Otherwise, they're going to be held to account. So that's what the court case is getting to here. Thus, the press, as a segment of the public, acts to assist the whole public in guaranteeing the openness and integrity of the trial process. But also, we cannot forget that a trial court, not just the trial, but everything happening in the trial court is a public event. What transpires in the courtroom is public property. Public property. This is a court case, a Supreme Court case. There is no special, say this word. Anyway, the judiciary has no special ability to control it, and that's distinguished from other institutions of democratic government that can suppress, edit, or censor events which transpire in proceedings before it. But here, the court cannot do that. That's what this Supreme Court case is saying. Now, just like other states we talked about, Michigan has a law that's been on the books, this one since 1846. And many Supreme Court cases have referenced the fact that this law has been on the books since 1846, that this law predates at least two of the Michigan constitutions, and that every judge by now definitely needs to know that you have to follow this law. But this law, in Michigan, it's MCL 600.1420, and it mandates that all sittings, is the wording that they use in the statute because it's from 1846, all sittings of every court within this state shall be public, except that a court may, for good cause shown, exclude people for one of extremely limited exceptions. Okay, so the exceptions are stated as this: witnesses in the case when they are not testifying and may, in actions involving scandal or immorality. Sorry, I'm blurring two of them. Witnesses, but that's just in terms of sequestering witnesses to make sure that when you have one witness come on and giving their version of what happened, when they give their testimony, that you don't have the next witnesses sitting in the courtroom hearing that so they can say, oh, yeah, I'm going to say it just like he said it. So you can sequester witnesses for that purpose, right? That makes sense, but that's not keeping the public out. That's why the witnesses are sequestered, meaning the witnesses are not to talk to each other, but they're not to talk to the public either. And then the law continues by saying you can also seclude minors from a courtroom where it's a case involving scandal or immorality. Wording of the 1800s, basically talking about cases like CSC, which is in Michigan terms for criminal sexual conduct. So if it's a rape case, then you can keep minor children out of the courtroom because it's not the kind of thing that they should be having to talk about or hear about, right? But unless there's into that exception, you can't even keep minors out of the courtroom if they're a party to the case or a witness to the case. Well, I have a right to be there somehow involved in the case, right? And then the last exception, this section, this statute, does not apply to cases involving national security. Well, obviously, if we had to sequester any witnesses in any trial for me or evidentiary hearing for me, fine, but I don't think anybody was arguing that any witnesses needed to be sequestered. That does not, it doesn't justify excluding the public, like we mentioned. And in my particular case, it was not there were no CSC allegations, although the deputies physically assaulted me. There's no rape allegations or anything like that. So there's not a need to exclude minor children from the courtroom, which means they can be there. And it definitely wasn't a case of national security. Excuse to say this law doesn't apply because of that.
This is kind of funny, but so you had said these arguments, and I don't think I remember the prosecutor responding to them specifically. So since you brought those arguments up and the prosecutor didn't argue back, no, she can't share this, wouldn't that in itself default it to your side, or am I going into a bigger topic? Am I making sense?
Generally speaking, so Lori's saying, hey, if one side brings a request and has a bunch of reasons, legal support for that request, and asks the court to do something, to rule one way or the other, to make an order for something, and the other side, in this case, the prosecutor, asks the other side, excuse me, where the other side does not come forth and say, oh, no, that's wrong, and gives their reasons why, their legal support for saying, nope, that's not correct, or no, the court shouldn't do that. If that objection is not really made and that request just stands and the other side's like, then the court in general is supposed to essentially default that request unless there is a legal reason not to. Because again, the parties, the people involved are the ones with rights. So there has to be some sort of legal reason for a court to deny a request of the people, of a person, of a party to a case. So if somebody's making a request to keep the public out of a hearing, okay, well then there's legal reasons why a judge should say, no, we got to keep this open. Or something like that, but especially where the party is requesting openness so the public can benefit from that, the court can't just say, well, I don't want that done, or this is my courtroom, or I have the right to control how things happen in here. None of those are legal reasons why they shouldn't have to default to approving of the request when the other side didn't make any legal objections. And that's what happened in this case. I'd have to double check at the prosecutor's response. That's a good point though, Lori. So remind me off camera to do that, to go back into that and see what they did respond in their huge 17 pages of response to all of my motions total. But anyway, I want to point out too that in my case, the judge, at least in one of the orders, circled or highlighted, whichever it was, I don't remember, underlined something, the part of the order, this gag order, that says, if I did share any of the information, any of the video pieces with any other human being, I was going to be held to answer for contempt of court. So essentially, he could try to throw me in jail for a contempt of court charge for sharing this video. So, yeah. Now let's look at the Black's Law Dictionary, okay? Because this is just this. I threw it in just for common sense, right? A public proceeding is one. This is a quote from Black's Law Dictionary that is widely accepted when needing to just look up what words mean, right? It's one that anyone may attend or observe. It's as simple as that. A public proceeding is one that anyone may attend or observe. So what did I do? In my case, I asked the court for two things. One, to clarify that I have the right to share with the public any transcripts and or video of these court proceedings, of all the court proceedings. And for, well, any such other relief as the court deems just and equitable. That's the catch-all phrase, I guess, if you want to call it that. So that's what I asked. Specifically, when you file a motion like this, you're supposed to file a proposed order, what the judge could simply sign if he were to grant your motion. And the proposed order is also included in here, and you can use this in your own situations or, you know, your own cases or whatever. So the proposed order, this is what he would sign if he, you know, were to realize what I was saying was true. Defendant has filed requests for transcripts and records of each of the court proceedings held in this case. The prior orders approving her to receive these copies indicate she shall not copy, release, publish, or post any part of these proceeding records to anyone else. Defendant filed a motion for declaratory relief and supporting brief on May 26, 2022, seeking clarification of her right to publish and share these records. The people filed no response to this request. So there you go, Lori. I must have already looked that part up. The motion was scheduled to be heard on June 2nd for July 7th, 2022, but has not been decided to date. Thus, on defendant's current ex parte motion clarification records, the court grants defendant's request. It is further ordered that defendant may share with the public or anyone else any transcripts and or video of any of the court proceedings in this case. It's pretty simple. I get to share the videos. That's all I'm asking. That's literally all I'm asking.
Now let's pretend the judge only stand because, yeah. So let's say he denies this, then doing this ex parte, can you appeal an ex parte to the circuit and then appeals and up the ladder, so to speak?
Yes, you can appeal any decision of a court, but I have to clarify with the court in my current appeal to the this issue is already in an appeal to the circuit court because he had already precluded me from sharing. So this issue is already raised. I've just brought it back in front of the judge again, but he has made this order repeatedly on these gag orders repeatedly so that I cannot share this information. So yes, this issue has already been appealed, and I just need to clarify that part of the appeal with the circuit court. And then when they deny it because they don't like to follow the Constitution or the law in the circuit court in Allegan County, then I will be appealing it to the Michigan Court of Appeals and to the Supreme Court if needed. So, do you think there's any other questions that we need to address?
Well, we had that one from a while ago. We kind of veered off. But earlier on, we had this question from Patty, and I thought, is there such a thing as law protocol? And I don't know if she's still listening. I wasn't exactly sure what she meant. Maybe you do.
Actually, no, I don't. Patty, if you're still watching on Facebook, if you could explain, do another comment here, explain what it is that you meant by law protocol. Perhaps, I'd be able to answer that for you. I'd love to answer that for you. I'm just not sure what you mean by that, so I'm not sure how to answer that. In the meantime, for those of you still watching live right now, if any of you have comments or questions. I guess I should ask Lori, are you watching to see if there's any questions being posted on
Yeah,
Rumble?
Yep, I am, and I didn't see any there, and I haven't seen any new questions pertaining to our conversation.
So I'm going to close out here. We'll keep our eyes open to see if anybody pops up with, any clarification on a prior question or new questions on any of these social media platforms that we're live streaming to. But in other words, it's inherently unconstitutional to have a gag order that's attempting to stop you from sharing video or what have you of a court hearing. Whatever happens in a court hearing is supposed to be public and remain public. Obviously, people can't all just tune in or attend at that very exact moment. No, you're going to talk about it. You're going to reference it. And in this day and age where we have video, I mean, they're claiming, supposedly, I guess, that it's a constitutional way to conduct these as open to the public, these hearings, by doing them on Zoom and YouTube and all that. Okay, well then, if you're doing them on your social media platforms and then promptly removing them, the videos from those hearings then can turn around and be shared elsewhere on the internet and made available for the public to see. And there's no reason why it couldn't or shouldn't. That makes no sense whatsoever. The proceedings of a court are presumed to be and required to be public. The rulings, the discussions, how they came to those decisions. I mean, I grew up with that notion generally, because think about the O.J. Simpson trial. Any of you who are remotely my age grew up thinking about that on TV for, I don't even know, it felt like an eternity. It felt like whatever year it was. I want to say 6th grade or something. You started by watching, we were watching live as OJ was driving across the interstate in his white Bronco. And then, it rolled into if the glove don't fit, you must acquit, and all that other fun stuff, right? We were seeing the testimony unfolding. We were seeing it happening on TV. And that was back, before internet was like a thing, back when my computer, if I had one, was Windows 3.1 or Windows 95. So at any rate, I mean, this is something that, we should be used to seeing. Think about the Johnny Depp trial. Think about any of those trials. They should be, the only reason why a court should ever put restrictions upon the press is if you have a bunch of people that are in the press, photographers, or, that are doing still pictures versus, video or whatever, and they're trying to set up or do their recording in some way that is distracting to the court proceeding, or in some other way it disrupts the court proceeding from happening as it should. That's the only way a judge should ever be able to say, hey, no, you got to get out of here, right? But if you have a member of the press that gets there before the hearing starts or the trial starts, and they set up their tripod and they have their camera rolling and they're quiet and they're being respectful and they're in no way in meetings, the judge has no right to preclude that. I will say that, I agree. The 3 exceptions in this Michigan statute, which I think are widely the kinds of exceptions that are tolerable across the country. If you have to sequester witnesses to make sure that from one witness to the other that they are telling the truth, that's still meaning the hearing is open to the public, just not those witnesses, and usually until their testimony is completely done, right? You can exclude minors, but only if it's a case of, immorality or, of scandal, such as a rape case where, you could exclude a minor, but you still can't even exclude them if they're a witness or a party to the case. And then, of course, national security. Well, yeah, if we have a court case about something, there's an argument over a warrant and it's relating to an issue of national security. Well, yeah, we're not saying make that open to the public so that the foreign enemy can go ahead and, get the inside scoop sense, right? So we understand that those are very rare and specific exceptions. But again, we're talking about The only time the public is actually allowed to be excluded is actually that third one, talking about national security cases. The other two are talking about excluding specific individuals and only in certain circumstances. So, what did I say? What R word did I say?
I'm not sure. I was reading that too. I wasn't sure what he meant.
Republic?
You can't.
What on earth?
Is that what you mean a liberty cause?
I don't know what word I would have said.
Our case? Oh. I'm not sure.
I'm not sure. If you want to shoot us over
for
text,
clarity. Yeah. Well,
shoot us over a text where you're spelling it out. I don't have any clue there. So now I'm curious and I want to know right now.
Yeah, I know.
I don't see a text from you, Liberty Cause. I'm looking at my text messages.
Oh, the 4-letter word that you were talking about. Which is one of those preclusions? APE. RAPE.
Oh. Well, then they're stupid and I don't give a shit. YouTube. I don't give a shit. If they're going to take me off because I'm using words of things that happen, then tough shit. I don't know. That YouTube, you're stupid. So anyway, I guess I'm going to get it off my thing.
I haven't looked into it, and I'm not sure if YouTube's included, but I do know I heard without looking into it that one of the state AGs is going after at least Facebook for censorship. So we'll see.
Oh, I did hear about that too, vaguely. Yes. Yeah.
Which that would trickle into potentially YouTube as well then.
Well,
depending on what it's about. I haven't dug into it at all.
Lots of issues we've kind of touched on today. The main thing is the openness to the public concept of court proceedings and what a judge is allowed to do and not do in terms of issuing those gag orders. So hopefully you guys have all been able to hear that much, if not see it. I know some of our syncing up hasn't quite gone as well as I've wanted it to. And don't forget, if you're live right now or you are seeing it, later on a replay or on a different social media channel than what we're streaming on right now, I'd ask that you go ahead and shoot us a message, an email, a text or whatever, or even a comment on here. Hopefully we'll be able to go back and catch all the comments later. What you think about the new camera angle and the lighting. I'm still not thinking it's that great, but I guess nothing can replace my Hudsonville beautiful solid oak office and the big bay window that I had in that room. But then again, it's not struggling to keep it at least 65 degrees in the winter. And, knowing that I'm looking outside, seeing a big pile of snow 9 months of the year. So sorry, guys, I'll take the beach any day over the nice backdrop and wonderful lighting. So isn't that ironic, though? I'm in the Sunshine State and I'm having issues with figuring out how to do good lighting on videos. Anyway, and we've tried just having the curtain open here as my desk is right at a window, but that makes me look like I'm more blue than human. And I love the Smurfs, but anyway. So let us know what your thoughts are so we can make sure to constantly make improvements. And please, everyone, there is a post that we've sent out. We've also sent it out in the newsletter. Sign up for that if you haven't already. You could do so on our website, Restore Freedom. Please make sure to fill out the survey. It's not a Google survey for those of you who truly hate Google so much that you won't even do a survey. But please fill out the survey, the non-Google survey, on our Restore Freedom Weekly episodes. I want to hear from you which platforms that you would be able to or interested in streaming this live if we were to switch up which platforms we were streaming. And I want to know which times you think would work best for you. I want to say I did not cannot put in certain days or times because I need to reserve time for my family. I know a lot of people would prefer, evenings or sometimes on weekends, but I got to raise my kids and spend time with my husband and finish remodeling projects and write briefs. And I got to balance that and have some kind of a life. We still have yet to take in a vacation since 2019. So please understand if I'm not able to hit those prime time slots for doing these kind of episodes. But I do want to hear from you. Look at the choices that are available. Let us know your thoughts, any and all that you would prefer that you'd watch it at. Please make sure to select those. If you want to join in on any of the amicus briefs or help fund any of those particular pieces of constitutional advocacy, there are specific links to do that have been in the newsletters as well as on the website. So please take a look at it for that reason. And keep in mind, we are constantly working on getting the new website fully up and half functioning from what will be on there, maybe a third, but there's still a lot already there. Again, remember to hit that like for this particular and share our website with people as well as cross-platform sharing. Let people know on Facebook about our Telegram channel or on Twitter about our Truth Social. Make sure that you are spreading the word out there so that we can make sure to keep doing our work to truly reach out there and educate people on the Constitution and the law. So together we can work to hold these government officials accountable and eliminate, quite frankly, 90% of these unconstitutional government agencies and offices that exist in the first place. So thank you so much for joining us today. I don't see any additional questions that have posted. I don't see Lori jumping up and down with any questions unless she's frozen.
Nope.
But again, thank you for all of your support. Please make sure to join us again tomorrow, Thursday, Friday, Saturday, and Sunday, where we will share a Wednesday way to get involved challenge, a Thursday Constitution segment recap of the things we talked about today, Friday's freedom fighting tools, Saturday's Restore Freedom Goodie of the Week, and of course, Sunday's biblical insight to this very important topic. And of course, next Tuesday, join us at noon. We will continue to run the poll and won't change the timing or platforms until we get some more results. So please join us next Tuesday at noon live on YouTube, Facebook, and Rumble. Thanks so much, guys. Have a great day.